Tonight on Insights, when can a trespasser or encroacher claim legal title to a parcel of land in Hawaii? Why is kuleana land so vulnerable to acquisition through quiet title suits? How prevalent are such suits in land transactions? Why do some say this is the last straw in separating Hawaiians from their land? This live broadcast of Insights on PBS Hawaii starts now.
Aloha and welcome to Insights on PBS Hawaii. I'm Laura Yamada. This past December, Facebook CEO Mark Zuckerberg filed 8 quiet title lawsuits in state court on Kauai. Now, this action was initiated to gain ownership or validate his existing claims for 13 parcels of land, each 1 acre or less in size, within his 700-acre oceanfront property on the Garden Island's North Shore. Now, the quiet title actions would force owners to sell their stakes in their land at public auction. This affects hundreds of owners of small pieces of land, including kuleana lands, the lands that the aina, the commoners, received from the Hawaiian government under the Kuleana Act of 1850. Mark Zuckerberg's lawsuits to force the sales of these lands were recently withdrawn, but land acquisition through quiet title continues to challenge local families who have inherited ownership of family lands for generations. Now, in some cases, the lands are split among numerous family members who may be unaware of their interest in the property. So we look forward to your participation in tonight's show. You can email, you can call, you can tweet your questions, and you'll find a live stream of this program at pbshawaii.org. All right, now to our guests. First, Paul Nahoa Lucas is a licensed attorney currently serving as senior counsel for the Education Legal Division at Kamehameha Schools. He advises the trust on issues relating to education, employment, intellectual property, and Native Hawaiian rights. Mr. Lucas is a former staff attorney with the Native Hawaiian Legal Corporation. Next, we have State Representative Kaniela Ing. He was born and raised on Maui and was elected in 2012 to serve the 11th House District, which includes the South Maui areas of Kihei, Wailea, and Makena. Representative Ing has introduced legislation during this current session through his House Committee on Ocean, Marine Resources, and Hawaiian Affairs to address issues with quiet title and kuleana lands law. Hawaiian historian Daviana Pu'omaikai McGregor is a professor and founding member of the Ethnic Studies Department at the University of Hawaii at Manoa. She is also a longtime grassroots organizer working for burials, protection laws, and protecting subsistence and water resources. She's a longtime member of the Protect Kaho'olawe Ohana. Professor McGregor is often called in as an expert witness for quiet title cases. And Dawn Ching, she served 14 years as Deputy Attorney General with the Land Transportation Division and counsel to various state boards and commissions. Her company, Ku'uvalu, specializes in resolving culturally sensitive and contentious issues, including work with developers and Native Hawaiian families on burial issues and in developing a management plan for the Science Reserve on Mauna Kea. So thank you, all of you, for joining us. This is a complicated issue. I mean, I'll be honest that, I was born and raised here in the islands, but this was still a learning process for me too, and I think for a lot of people here, even who were born and raised, that there's a lot to understand, and a lot has happened over the years. So let's set the stage first and just talk about what it is at its basis that we're talking about. First and foremost, kuleana lands. I know a lot of you could talk about that, but maybe we'll start with you, Daviana, first, to explain to people what exactly is kuleana land?
Well, in 1848, you had what was called kamahele, which was a process of establishing private property ownership in Hawaii. And really the process had started with a Declaration of Rights where the king and the Council of Chiefs guaranteed that the people and all of their lands and their property would be protected. And the 1840 Constitution declared that no one in Hawaii owns land not even the king owned land at the time. The king held the land in trust for the chiefs and the people. But the king was forced under pressure of foreign residents to grant a private property system. And so finally that process began in 1846, and there was an announcement that the Board of Commissioners who were appointed to conduct this process made, and it was announced in the Polynesian newspaper, and all people had 2 years from that date, which would have been February 14th, 1848. People had to come forward with their claim by 1848. And in the meanwhile, between 1846 and 1848, the commissioners sat down with the king and the chiefs. And at that time, all land had 3 layers of interest in it. The king controlled all of the land, the chiefs controlled lands that were under their purview, and the people who lived on the land also had interests. So when you establish private property, you have to end up with one owner. And you have 3 essential interests.
This is a brand new concept for people.
Exactly, yes, and there wasn't even a term for it. They used vai, which means wealth, you know. And so anyway, the king and the chiefs agreed what lands they would get. The king got 2.5 million acres, and then he turned over 1.5 million of that land to the government. The chiefs got 1.6 million acres. And the king retained for himself 984,000 acres, and that became what we call the crown lands. But there was a reservation made on the lands that was granted to the crown and to the government and to the chiefs. And that reservation was that it was still subject to the rights of the people who lived on the land. And so the process by which the people who lived on the land could claim their land came under the purview of the Kuleana Act. And between 1848 and extended through 1854, the common people would come forward to provide testimony. With they had 2 witnesses. They had to pay for a survey, which cost about $12 at the time. But you know, we're talking about people who were not had any money.
Put it in context.
So it's probably like
when this was.
Yeah.
And what people were used to at the time.
Right.
We're talking about farmers oftentimes.
Exactly.
And fishermen and people who
And they were
weren't
not
used to
selling.
being in a
Yeah.
court or having to deal with all this documentation.
Yes.
It was really
And as it
difficult for
turned out,
folks.
only 29% of the population applied for and got land. And the amount of, so there was 8,205 awards, Kuleana awards given. And that went to, that represented about 29% of the adult male population at the time. And the total amount of land was 28,600 acres. And just so you get an idea, Kaho'olawe is 28,800 acres. So all the land that was granted through the Kuleana Act in Mahele could have fit, if you put it all together, could have fit into the island of Kaho'olawe. And between the chiefs, the government, and the king, the rest of the land was, equal to the size of the other islands.
And as time went on, Dawn, your family was part of Kuleana lands and had to go through a lot of this, and we'll get more into it as we go on, just what's happened over time. But even after the process was in place and people were able to get titles, it was still very difficult for families to understand the system, to be able to do what was necessary, to be able to set themselves up so that over time they'd be in a position to preserve the land when necessary.
It was a difficult transition. Our family, my mother is Edna Kealoha Paole Ho'okano Shirama, who is from the Ahapoa of Kahalu'u, and her family goes all the way back to original awardees of the Kuleana lands. I went to Louisa Cook and Iokeve Ho'okano. They had several, and these were non-contiguous parcels of Kuleana lands up Maka, where they farmed. They had taro, where they lived, and then they had a fishing village on the Makai side. But these were families who were used to just living off the land. They farmed the land, they raised their family. My tutu, in fact, is buried on our Kuleana lands. But as time progressed on, as the surrounding lands were sold or developed, their access rights were impacted, their ability to continue to farm the lands were impacted, as well as many family members moved away. So our family, the original awardees, Ho'okanos, there were 10 children, so we call them the original heirs from this Kuleana lands. But if you can only imagine, out of 5 generations later, those 10 heirs, the number of children and heirs. So we had a family reunion, and in 4 months we had 700 people come.
Oh my goodness.
So just try to imagine you have 1,000 people who have an interest in kuleana lands, and then you have an adjoining landowner who, in our case, filed a quiet title action and a partition action against us. And that was 1993. So,
Wow.
20
Dealing with
years
this for quite some
litigation
time.
that has not been resolved.
And we're going to get to some potential solutions coming down the road, but this goes into a lot of what, Naha, that you've had to deal with over the years with the issue of quiet title coming up to deal with situations like this. Again, an extremely complicated issue, in part because of what's happened over time. So and people have been hearing that a little bit more, as we mentioned in the beginning about Mark Zuckerberg's case. I think that kind of perked a lot of people's ears up as to what this is all about, kuleana lands and a quiet title. So explain to people a little bit before we get a little further into it, what exactly quiet title is and how this plays into his case and what we're all talking about here.
So quiet title is quiet is a legal term of art. It just means to determine the title. And it usually happens when you have multiple interests and you want to basically determine it through the legal process. It's usually matched with a partition action, and that's why they say quiet title and partition, because once the title, the owners have been determined, then you move into the second phase, which is partition, and that's to determine whether or not the parcel can be carved up or partitioned in kind, as they say. And if not, if the owners cannot get their own plot of land, then the property will be sold, and it's usually sold at auction on the steps of the courthouse. And it's worked to the disadvantage of Native Hawaiians for many, many years.
Could you think about the cost?
The cost, first of all, to file an action such as this, and the only way that you can become, entitled to file a quiet title, like someone like Mr. Zuckerberg, is you have to purchase an interest in that kuleana. You can't, if you're the surrounding landowner, you can determine the boundaries of the kuleana, but you don't have an interest to break up the title. So, if you purchase an interest from one of the heirs, you can then proceed down to the end of the action, which is the partition and the sale of the property, and then under the law it goes to the highest bidder. And so you have the money, you can always be outbid.
Yeah, so the issue here is someone like Zuckerberg, he can just find one of these kuleana landholders, purchase, and then initiate quiet title action and partition for the other 99%, and then capture all the rest. That's where it seems highly unfair for these.
So let's go back, and we're definitely going to talk more about that, and just explain a little bit more. And any of you can jump in about Mark Zuckerberg's lawsuit. Explain what exactly it is that he tried to do with this lawsuit.
Well, I'm not entirely familiar with the facts, but I do know that he was a co-plaintiff along with Carlos Andrade, and they were initiating the action basically to determine the title, and then once title was determined, to partition the property.
Because he has this nice large slice of land out on Kauai that he's purchased, and he's talked ever since then about it being a sanctuary for him and his family, which of course many people here in the islands and elsewhere in the world would love to have. And that's where the issue of the kuleana lands and the quiet title comes in, because there are people that have rights to parts of that land, and this is where it's gotten sticky for him.
Right. I mean, I am assuming what we read in the paper is Mr. Zuckerberg bought an interest in one of the heirs of the property. So as a co-tenant, he could then file the quiet title action, and his co-plaintiff was Carlos Andrade, and force, as Naho said, a determination of title. Once the court determines title, who are all the legitimate owners of the property or have an interest, then you can force a sale, a partition. And so at least all I know is what I'm reading in the paper, that I believe that's the facts, is he acquired an interest in one of the property owners, and accordingly filed the quiet title action and then forced a sale. But I really appreciate Kaniela's point about you can have a very small interest and then you can force a quiet title action. And if you've got enough financial resources, you can end up purchasing everybody else's interests, even though your legitimate interest is only a 1% or 10%. And so hopefully there'll be some change. I think that that's what you're proposing to do.
Yeah, so look, these are Nahoa, Professor McGregor, Don, these are people that have been working on quiet title, experts in the arena. That's not me. I just trying to fix where I can. So we're going to have a hearing on Tuesday, and if anybody have good ideas for the bill, I'll be happy to include it in. But where I'm coming from...
You've been very involved.
Yeah, where I'm coming from is more of just like representing what I felt the community was trying to tell Zuckerberg. When you say, I want to do what's best for Hawaiian culture and respect Hawaiian culture, fine, but you gotta learn it first. You don't know it from being a tourist 3 times. You can't, like if rural America anywhere, if you come into any town, buy 3 acres and you're a billionaire, people are gonna throw a fit. And you only show up once a year, like you don't even enculturate or talk to the community, explain your intentions. Now you magnify that to 700 acres. Just transpositionally, we should know like the scale of this. 700 acres, like in paradise now, where they film Jurassic Park and all that. That's going to be an issue. Just like who needs that much land in the first place? No matter how rich you are.
You had some pretty strong words for him. I think this is a PBN article recently. You said you have a mainland billionaire exploiting our legal system and bullying his way through local residents, all to build his beach playground. This is not the intent of the law. And that's why you've taken some action in the legislature.
Well, yeah. So growing up in Hawaii, if you have an issue with somebody, you try to go up to them, talk story, and figure it out. You don't initiate conversation by a lawsuit. That's the first time somebody's families heard from Zuckerberg was, you've been sued. So what do you do? Even if you're a working class person, you're gonna try to lawyer up yourself. So, Zuckerberg's talking about, I'm just trying to identify these people so I can pay them out. Yeah, you might get a payout, but NHLC, if you talk to them, a lot of these people end up incurring more legal fees than they ever get back, so they lose money.
So this is something that he said in response, and that's where the lawsuits have been dropped for the time being. He said, upon reflection, I regret that I did not take the time to fully understand the quiet title process and its history before we moved ahead. Now that I understand the issues better, it's clear we made a mistake. And the right path is to sit down and discuss how to best move forward. So that's where it stands right now. Well, we don't know at this point exactly how it's going to move forward, most of us. So, and I know we're going to talk about some solutions a little bit later in the show, but what is your response to his reaction? Is he maybe, he is from the mainland. He is of the 1%, I guess you could say. But he went through the system legally. There was nothing illegal about what he did, and he's very fortunate to be somebody who has a lot of money, like some people do in this country, and is able to do this because of that money, which is legally, at least, his right to do so. So what is your response to his response then, saying, hey, I made a mistake and I want to go forward in a different way now?
Okay, so all the facts will come from these 3 minor opinions. And the older I get and the more, a little bit more mature I get, maturity is like knowing what your opinion is really.
No, you're making your own part of the process.
But definitely said, I gave him this huge mahalo in the media after he came out with this statement, giving him the benefit of the doubt. But the fact remains, talking to these families, they're still very reticent to accept everything as POW. Andrade still has his lawsuit. People think that he's acting as a sort of screen for Zuckerberg. He's still backed by Zuckerberg. Folks feel that, he's happy to sit down and talk. Well, there's no community meetings. My office hasn't heard from him. NHLC hasn't heard from him. You might have dropped the lawsuits, but there's still, the context, you have eight lawsuits through his holding companies with these local Hawaiian names. And it equals about 14 acres. So within that 700, we're just talking about 14 acres now. There's still that land within that rock wall he built, regardless of his lawsuits or not. So he has the duty to parcel off. Like what I would like to ask him is just parcel off 14 acres then, or more. Be a better neighbor. 30 acres. Allow the families to decide what to do with that land. Form their trust as Don's family did, and and then maybe leave like some other space for beach access and trail access for everybody else. And you really have an opportunity to set an example of what a good neighbor could look like. And you know, I'm willing to give him the benefit of the doubt, but so far, I know he's been busy. I think he's running for president or something from state to state. I don't know.
Yeah, he's got a lot going on, no doubt. So that's sort of an example of how things have played out in one way.
But he kind of bought into a bad situation because
Yeah.
the previous owner, Pfluger, was a terrible
I'm
neighbor
glad you
to
brought
the
that up. I
other.
was going to bring that up at some
To
point.
the other, you know, I mean, and I know why Carlos is doing. We used to have conversations with
Because that
Carlos.
used to be part of his Pfluger's land.
And
Jimmy Pfluger,
Pfluger was
our
trying to block
dealership.
access to the lands that the kuleana owners had. So it seems at least that Zuckerberg is trying to work with the families and acknowledge that they have interest in the land, whereas Pfluger,
Well,
had not previously even acknowledged that.
agreed. One concern of mine was if you read the complaints, it wasn't just quiet title. It was actually adverse possession, which I learned a lot from these folks in the green room earlier about. It's basically corporate squatting law. You stay in this, you pay property taxes and maintain this land for X amount of years. It's yours.
Well, explain to people a little bit again who don't know what
Well,
adverse.
Zuckerberg he had adverse possession in
Possession
his
is.
complaints, and he was basing it on not just his stay on the land, but Pfluger's as well.
Yeah, right. Well, adverse possession, I think, was a law in 1870 or 1875, and it was a way, because there was a lot of parcels that were abandoned, so to speak, but I think it was a way for legally stealing land away from the rightful owners.
This is the way that the law works. If you're on that property within a certain amount of time, which has now been extended to a longer amount of time, you have certain rights to that, and so that's where we get into the situation
And I think
of so-called
what
squatting.
also needs to be sort of discussed is Hawaii law is very different. It's unique from other Western laws, and a lot of these concepts, adverse possession, quiet title, is really a Western concept. In Hawaii, you have the right traditional customary practices, very unique to Hawaii. You don't have the right to exclude everyone in Hawaii, and that's the land that you buy. I mean, the king did that when he conveyed all the lands. It was subject to the right of native tenants. Kuleana lands in itself has a very unique status. You continue to have the right to water, you have the right to access. So kuleana lands, in my view, and as Davey described the division, out of 4 million acres, kuleana landowners only got 28,000. And that's really what we're talking about, is a very, very small amount of land that Native Hawaiians who were originally working those lands, their ability to continue to keep the land. And that's what our family, we wanted to make sure that our future generations had that connection to that land. But we needed to find a much more manageable way to do that. But I think what we need to remember is, and I'd like to give Mr. Zuckerberg and others the benefit of the doubt, that when they bought land in Hawaii, they didn't realize that we have a very different, unique system. And so around the notion of kuleana lands comes responsibility. It is reciprocal. You have to acknowledge that.
Because, oh, go ahead.
Yeah, no, I was just going to add on to what Don was saying. Is to that point about one of the hallmarks of Western property law is that we have the ability to exclude, keep out, no trespassing. But the whole subject to the rights of native tenants means that was never given to the landowner. It was subject to the rights. It was reserved in the deed by the original owner, the king, and said, if we do not give these tenants the rights to access into the uplands to gather what they need to, if we don't give them water for their kuleana, if we don't have the right of access to the shoreline, these properties are going to be valueless. And so you cannot exclude that, because Mr. Zuckerberg could not exclude those people from getting to their properties. And the kuleana, again, going back to previous points that were made, is a lot of people that come here, they don't understand Hawaii's unique land tenure system. These kuleana are imprints of a traditional land tenure system that may have gone for some people, but other people continue to practice it. Many of the families still continue to access their property. They still intend to develop the property. And so landowners today, you think we've gone away from the big, from the days of the past where kuleanas where landmarks were bulldozed, and fields were planted, or cattle were grazed so that the original owners could not go back there and basically establish an adverse possession claim. You'd think that we're a better people because now we got a lot of money and we're not going to do that kind of stuff. And, we still see that today. We still see it happen. I think that's what rubs a lot of people the wrong way.
And I think some of the viewer questions that are coming up really leads into sort of what's happened over time and how complicated this has become, and why I don't envy anybody who has to be an attorney handling these types of situations, or in land court for that matter. Maybe I'll ask you this one, Dawn. This kind of plays off you talking about your family and how your family of 700, as you mentioned, managed the family land. This is coming from Lloyd, by the way. And then trying to, over time, how to deal with that, because we talked about there are all different levels of interest from family members, different levels of exposure and knowledge, different levels of income, all having to come together and try to find some resolution.
Now so when the lawsuit was filed in 1993, that was a real challenge for us because everybody has an interest. So how do we manage, one, the litigation, and then how do we manage the future of the land? So what our family did, the Ho'okano family did, was, with the help of our attorneys, establish the Ho'okano Family Land Trust. Original 10 heirs. Each family line had a trustee. The trustee's responsibility was to take information back to their family, but decisions were made by this board of trustees. So rather than dealing with 700 or 1,000 people, the board of trustees representing each family line would make decisions involving the litigation based upon the board of trustees. And so it was very manageable, but it did require acknowledging that you weren't required to join the land trust. So we had other family members who didn't join the land trust for whatever reason, but a majority did. So one of the advantages, and the purpose of our land trust was really two things. It was to preserve the land in perpetuity in the hands of Ho'okano. So in fact, to be a member or a beneficiary of the trust, because in a land trust, you really don't own real property interests. You own an interest in the trust. The lands are conveyed to the trust as a share, but you have to be blood. So in our family land trust, you have to be related by blood. You cannot be by marriage. You cannot even be hanai. You must be blood. You must be a ho'okano. And, but it was to preserve and to prevent partition actions. So one of the advantages, when we do go to court, we represent 60, 70% interest of the property, which for purposes of litigation gave us leverage. So when we came into the court and we said, we want to preserve this land, that although the adjoining landowner, Anderson, filed the action, the court did give deference to what the land trust, what the trust in itself recommended. If we went individually, if 700 of us went individually, the court probably would have put this out or said,
taking a break and not come back.
But but the court had to just deal with a board of trustees. But on the other hand, we have to also go back to our family and keep them informed.
And I think this leads into the next question from one of our viewers, Joanne. And maybe you partially might have answered this for her, or maybe Nahoa could do the same. But she was asking along that same line. She thinks that they have a quiet title case and they're sharing a parcel, and she wants to assure her family that she can continue ownership if someone buys a share. So she's in the middle of this process trying to figure out what to do and where her family stands in all of this. So maybe either you or Nahoa can chip in and help Joanne out a little bit.
You're always free to purchase, a share from one of your co-tenants. And the harder question is, how do we agree upon a price, to sell it that is fair to everybody? And I think, in some of these situations, if the family is in agreement, you can have the property appraised. If not, you need to probably go into court And as I explained, under the partition statute, there have been changes in the law that actually that were effective as of January 1st of this year, which really do give that opportunity. It still means it still doesn't mean that the property cannot be sold, but it does allow for that co-tenant, should they decide upon where they can't agree to a private appraisal and determination of interest, they can still have a process under the law.
I'm sure a big part of it is coming forward early as much as you can and having a voice in the process. As soon as you possibly can, hopefully getting the information you need to be a part of that process. Maybe this is a question for you, Koniela, and having to do with possibly how we can deal with these laws and policies in the future. This is from Greg from Makakilo asking, should there be a limit on how much property new buyers can buy? He has a concern about inflation, but I think overall, is that something that would even be discussed? It sounds like a very sticky legal situation to put those types of limits.
I'm an attorney,
possibly.
but constitutionally, that might not hold much muster.
Yeah, you can't do that.
And then there's lots of, every time we talk about home housing, affordable housing, they go, why can't you just stop mainland buyers? It's just, you can't. It's illegal.
Another person asked, I think Timothy's saying, is it possible for one person, he's saying Mark, to get so much land from a small island? So
how is it possible? Money, short answer.
Yeah, maybe.
I mean, you have the 5th richest person in the world with the world's best team of lawyers, best PR professionals. That's what's so scary about these cases. And when you partner with downtown law firms that are infamous for targeting, because what happens is defendants, they end up paying for the plaintiff's legal fees and the costs. It can be to the tunes of 5 figures even, or even more. And that shouldn't be the case. And they tend to target the people with the most resources out of all the plaintiffs. So NHLC was telling me that oftentimes they want to represent somebody, but they warn them, hey, your house might have a lien put on it if things don't go the way we want, and they back out. And that's a real challenge as well.
Yeah, maybe a better course, rather than limiting the number of acres or land that you can buy, that if you purchase land in Hawaii, you have to take a course, or you have to, part of this is, we want to be, education. We want to give people the benefit of the doubt, but I think they have to come here and be respectful for the way that our land tenure and the way that we manage land and how we value land. Land is finite here in Hawaii, as is our resources. So perhaps what we should do is encourage or mandate them that when you buy land in Hawaii, you have to go through some kind of a course that helps you understand kuleana lands, traditional customary practices, those kinds of what are inherent rights in Hawaii, why our land laws are different. So when you come in, you're buying land knowing what you're buying, and that you're not surprised when the community is up in arms because you're doing something contrary to what, the way that we've been raised, our values. So maybe
I think we can have Daviana teach the course.
There you go. She's already teaching the course.
There's a request for your services. Here's another suggestion from Andrew DaCosta. She says maybe it's time to provide free legal services to Kanaka Maole who need to file claims over kuleana lands. Maybe that's something in the legislature that possibly funds could be allocated for something like that.
We heard the oil budget yesterday, and we put in an extra $2 million. Wow.
Oh, wow.
$2 million for
It's coming right?
No, we did $2 million for legal services. Now, will that get to the legislature, given the history, the recent history with the Nelson case and a sort of anti-Hawaiian sentiment in the square building? Maybe, maybe not, but there is some political will, at least among the Kanaka in the body, in the House and Senate, that would support that sort of thing. Also, this is a prime opportunity for NHLC to fundraise. If they, found the right message, they could probably do a drive to get a lot of small donors. So, hopefully they take advantage of that.
But they also have a conflict of interest too, right?
Yeah, so maybe the viewers don't know that the Office of Hawaiian Affairs gives a grant since the early 1980s to the Native Hawaiian Legal Corporation to represent Native Hawaiians who are defendants in these type of quiet title actions.
Right.
And they pay a sliding scale based on their ability to pay. It's not charged at a commercial rate, but that is one of the great things about the Office of Hawaiian Affairs and Native Hawaiian Legal Corporation is that they've been able to at least go into court and to represent those Native Hawaiians who otherwise would not have been able to do that and provide legal services at a reduced rate.
And maybe if I could make a plug for the UH Law School, Richardson School of Law. I mean, even establishing a clinic there, they've got great opportunities there where you can have law students partner up or create a clinic, because I think they're just building a clinic.
Right.
So, I mean, that would be having Hawaiians having options, and you've got wonderful Native Hawaiian lawyers coming out of there. I mean, quite frankly, I think, in my view, that's changed the dynamics of a lot of real property and quiet title is access to legal education. The fact that Richardson School of Law has graduated so many Native Hawaiian lawyers who have been willing to help in whatever way that they can. So the more we can promote, in my view also, if there's a way to create opportunities at the UH Law School for some kind of services like this.
Daviana, this is something we were talking about earlier in the background there is building that trust, I think, also from the Native Hawaiian perspective and the local perspective to reach out and feel comfortable with people on the other side of the table, whether it be lawmakers or lawyers or whoever is part of the legal process. How do you bridge that gap? How do you help make that a process that they feel more comfortable in and feel more engaged in, to where they can do more to help themselves and what belongs as part of their family ancestry? What do you think is going to help?
Well, I mean, I think once you get an action against you, you seek out help and assistance. Native Hawaiian Legal Corporation is the primary entity out there that they specialize in the kuleana cases and helping to document the genealogy that is required to show your title to the land and trace your genealogical ties to the person who acquired the title at the time of the Kuleana Act. I mean, that alone is very arduous to show that genealogy. What's happened historically in a lot of communities is, in Waiahole, for example, Lincoln McCandless acquired all of the land in Waiahole Valley by making arrangements with kupuna and giving them money or loaning them money, and then once the loan was paid off, it was expected that he would have filed the change in title, because title's turned over when the loan is made, and then when the loan is paid off, the title wasn't registered, and then he went in and claimed it. And the other aspect to as possession is not only living on or using the land for originally 10 years, now 20 years, you also have to pay taxes on the land for 10 years or 20 years. So in some cases, large landowners would acquire use of a kuleana through an elder and then offer to pay the taxes. And then when the time came, they would go in and file claim title
oftentimes
to it.
with the plantations and with the ranchers, this was happening.
Yeah, and then the elder would pass on, and then the children didn't know of the arrangement, and they were unaware that in some cases, if they moved to another island, they were unaware that they still had the title interest to that property. I mean, a lot of neighbor island people came to Oahu and they lost track of their interest in the land on other islands. And so the plantation or the rancher who had made this early arrangement would just go and adverse possess and claim the land.
And my understanding too, as the land changed and as different owners came in, the few landmarks that were there sometimes, whatever it was to bind someone to something legally, was now gone. So that made it that much more difficult to try to figure out for them to have a case.
Right.
They call them floating kuleanas because they can't find the boundaries. The boundaries were all based on a rock wall or a kukui tree, and now it's a sugarcane field, or it's a paddock that's being fenced in. So,
and then if you can claim that you have, can trace it as your land, it's surrounded by land that's zoned for resort or for a very high-priced home. And so people cannot afford to pay the taxes on the land and retain it. So then you have so many heirs, sometimes at 20 to maybe 100. Right. And the easiest thing for them to do is to sell the land rather than to continue to pay the taxes.
Except there has been, through the efforts of Office of Hawaiian Affairs, my mother did file, you can get a kuleana land exemption. Right. So rather than paying, if, for example, what Daviana talked about, a lot of kuleana lands were along the shoreline or in areas that are now subsequently zoned a higher, where you pay a higher real property tax. You can go in for an exemption, but you have to be the original, you have to be able to show ties to the original kuleana owners. You can't have bought a kuleana and then claim the exemption. You have to be an heir to the original kuleana landowner.
So I think what a couple of our callers wanted to find out about was what can be done to assist through the Native Hawaiian Legal Corporation. Are there either grants or are there other exemptions or other things that will help them financially to be able to start this process?
You mean for the kuleana owner?
For the kuleana.
Yeah. So as
owners.
Dawn had just mentioned, there is some of the counties have passed exemptions or required a very minimal flat fee for those owners of kuleana who can actually trace their genealogy going back. And so that's a huge...
It is. Makes a difference.
Yeah, a huge difference for those people who have historically, some of the family members have paid the taxes, and others who we call the deadbeat relatives who do not, but they still have an interest in that kuleana. And of course, there's animosity and hard feelings about that. Having a flat fee or having a waiver of that is a huge solution to it. The other thing is just trying to come together to manage the property in a way, because you know, aside from external threats, you have your own internal threats, and that's the disputes between the family members. And some are able to do it. Others just, you know, they after the original family members have died off, the interests fractionate, and then you're talking many people. Some don't even have the interest, and they're using the property. And how do you do all these management solutions? One of them is the private land trust that Dawn had mentioned, similar to large land estates like Kamehameha schools, where you have not the owner hold title, but you have the trustees hold title. And so as Dawn had mentioned, the owners convey their interest into the trust in exchange for shares in the trust. They establish through the trust's governing instrument how many trustees are going to be and what representative lines they're going to represent. So instead of 800, you're down to 8.
That sounds better.
No, it's manageable. I mean, I think one thing that I would recommend, if Hawaiian families, if you know you have a kuleana land, or if you just own land in general, and you are vulnerable. And so to the extent that Hawaiian families can be more proactive, think about, because if you die without a will, your land exponentially increases, you know, it gets split by all your heirs. So if Hawaiians can think about using different mechanisms, for our family, we use the land trust. Others have established LLCs, others have established other means of holding title to the property or managing decisions. And so if there, because many of our kupuna have passed away too, or the elders, but if there's a way that the families can begin to start thinking about how do we as a family make decisions about this land versus being in a position where you have to defend a lawsuit. That's really difficult, because at that point in time, you're panicked.
You're on the defense.
You don't have money for the lawyer. You're trying to scramble to get everybody. So if families, and you know, if you know, whether it's the University of Hawaii or some organizations or OHA, can begin to have seminars for Hawaiian families who own kuleana lands. What are some of the things that you can do to protect those lands? I mean, for our family, in our land trust, we've got a provision that says, before you sell out of the trust, you have to give the right of first refusal first within your own family line, and then if your family line doesn't want to buy it, than to someone else within the trust before you can sell to the outside.
I think we have a little less than 10 minutes now, and this is kind of rolling in. What I wanted to get to was just different ideas and different solutions and different things that people are working on to try and get through this very complicated issue. And I just wanted to make sure that I mentioned one viewer's, it's more of a comment maybe more than anything, and it's something that you have to deal with. He says filing a quiet title is not stealing. It's allowing anyone who may have interest to come before the court. So that is the reality, that this is a legal process, as much as it's easy to say,
well, the question
this is a person coming in and they're from the outside and they have a lot of money, it's easier for them. It is still a legal process.
Right, but the question is why initiating action in the first place? That there are people that buy lots of land with kuleana lands somewhere nebulous in between, it's undefined, right? It's just sort of there, and they leave it. And they let people traverse, do their thing, fish, hunt. Why would you want to initiate a quiet title action and identify and partition? Probably because one, you don't want local people walking through your property. And two, maybe in the future, you want to parcel out some land, sell it to a hotel or condo developer. Those are the only real two reasons why somebody would even want to do this.
Well, just to be maybe play a little bit of devil's advocate, because there's no Mark Zuckerberg here to defend himself.
Right.
But if I or anybody would think about land that they buy somewhere and they want it to be, as you mentioned, to have a family sanctuary and have it as their own if they purchase the land. Whether it's Native Hawaiians or people from another country or whatever going across their land, people going across their land, maybe you wouldn't want that. Maybe you'd want privacy.
No, understood.
We should separate out the issues. So one is, when I used the term legally stealing land, I was not referring to quiet title action. I was referring to adverse possession. And adverse possession, as a part of adverse possession, you initiate an action to show your interest in the land. So it's when quiet title actions are linked to adverse possession to take away someone else's land and claim that you have used this land for 20 years and now I'm paying, and I paid the taxes over those years and now I claim title to it. That is taking someone else's land away from them, the rightful owner. Quiet title is true. It's not in and of itself taking land. It's only when it's linked to an adverse possession action, or linked to a partition, where the reason why you want quiet title is to have all the heirs come forward and then force a partition and a sale of the land, and forced auction.
And if you look at,
and that's not, it's a process that is separate from adverse possession.
Except in the Zuckerberg cases, which in the complaints there are quiet title, partition, and adverse possession all right together.
And this just all leads into how complicated the law is, how it's been tweaked here and there over the years, the different statutes, some of it now conflicting, and part of what you've been trying to do and what you're also doing this legislative session. Tell me about some of the bills that are coming forth and how you hope it will help the process.
Okay, the general issue is, well, the Zuckerberg, first of all, if there's any good that came from these lawsuits, is it brought the issue to the fore. Worldwide, I was able to talk about the mahele to a large audience, which is great. And part of the reason why the viewer's right. It's not illegal, and it's because people in the Square building, like me, have ignored quiet title law for too long. Last year was an exception. We passed a good one, but we have to update these obsolete laws. So, anything we can do to, right now, quiet title action is weighed very heavily towards the plaintiff. And anything we can do to make it more of a level playing field for the defendant, I'm going to try to push. So, I think the Ho'okano model of the land trust is a great one. And before a plaintiff can initiate quiet title, they should allow these families to form that trust and then enter mediation.
That's House Bill 860 that
this
you have.
This is 860, which we will hear on Tuesday, and you could actually submit testimony online starting tomorrow, and come out in person too to the state capitol.
What exactly does House Bill 860 do?
So, gotta allow the families to form a land trust, enter mediation before litigation, because that's where it gets really expensive for these families. The defendants aren't going to pay the costs.
Right.
For the plaintiffs. Right. And we might add this other part, which is, earlier we talked about the problem of you just need one of one interest, and then you can try to take the rest. a 50% clause. The claimant's got to own the 50% of the kuleana lands before initiating quiet title. That might be a little bit more controversial, but the other three, I think, shouldn't be something that people like Mark Zuckerberg would disagree with. You know, why not enter mediation? It'll save you some time and money as well, because these quiet title cases can last for years.
Yes, our family's is a 23-year litigation, but I really do appreciate the fact that the irony in our family's quiet title cases, we as Ho'okanos, we knew who owned the property. We owned it for generations, but under the quiet title law, there was an action to force us to pay for his attorney's fees. And I mean, you're paying for your own attorney's fees, and then you have to pay for his attorney's fees, because the law, the intent is, well, the quiet title action is there to benefit all parties. But that's really archaic. It's not. It's really there to benefit the plaintiff. So the fact that if the law can be changed where the defendant is not required, because most of the defendants are Native Hawaiians who resist the quiet title action, more particularly the partition action, that it's really unfair. You're almost getting hit twice. Your land is getting taken away.
Right.
In many cases, your land does get taken away. It's sold at public auction, and then you still got to pay for attorney's fees, and you have to pay for the commission to auction the land. So,
insult to injury.
yeah,
Here's a thought from Aaron on Kauai, just throwing it out there. He asked, what's the legality of moving kuleana lands to a different area? Is that even possible? Is that something that would...
I mean, to make
Aaron's
a land
curious.
exchange, you would have
Yeah,
to.
you could
you
do
could
a
do
land
that.
You could do an
exchange,
exchange of land,
you
yeah.
know, acre for acre, or but as you know, again, it would have to be something that the owners agreed to, or and had some kind of court approval.
because most kuleana lands, that's where people lived, and most Hawaiians, that's where you buried.
Right.
So it's really difficult. I mean, I'm sure maybe in some instances you could do a land exchange. Mr. Zuckerberg, if he wants to put the 14 acres in another location rather than in the middle of his property. But I would suspect that most of these kuleana lands have ancestral burials there, and it's very difficult to be apart from that. So while that may be an option, there are other considerations as to what are we separating ourselves from. Most of our kuleana lands, you have a particular connection to that, or you have, they're sentimental. There's also access rights to waters. So that may be something to explore, but there are other issues.
I just wanted to add, though, that not all land that Hawaiians own and received is kuleana land. And in fact, there's more land that Hawaiians acquired through purchase during the 1850 to 1860 auction period and under Homestead Acts than what was granted under the Kuleana Act. And so those lands that Native Hawaiians acquired through purchase from the government or purchase from under our Homesteading Act also are subject to quiet title and have the same issues of multiple descendants and heirs trying to figure out how to hold on to their land or pay the taxes and deal with these quiet title issues. So it's not just an issue that relates only to kuleana lands. It relates to all lands that have been sold and purchased. And there was also a movement among Hawaiians to form land hui, or land organizations. And so you have several families pulling together their resources to get 200 or 300 acres of land together, and they have multiple descendants now. So in those cases, it's even more complicated with the land hui situations.
But that's for another episode.
That's right. We only have a couple of minutes left, but no doubt, as you mentioned, we've got a hearing coming up, and this is something that's very emotional for a lot of people, and people are starting to understand how expansive these laws are, and how, whether it be with kuleana lands or quiet title, this really does impact or potentially impact a lot of people here, Native Hawaiian or not Native Hawaiian. Anything else? Any other final thoughts as to what's coming forward in the legislature and what people are talking about to try and add a little bit to this? We don't have a lot of time left.
Okay,
but
we're going to need a lot of support because we have three
Tuesday.
great. We're all attorneys here.
I'm not.
All right. Well, we have two great attorneys and one great professor here that are on one side, but they're all types of attorneys. And the law firms that are on the other side, the ones that represent folks like Zuckerberg, they're big political forces in campaign contributions, in testifiers, and just, they have the right connections. So, and the landlords, the big five is still around today, right? So, the second largest landowner in the state still uses quiet title and adverse possession laws. So to get something like this through, it's going to take a real groundswell of support. So, I hope people call their legislators, come in and testify, submit testimony online.
Well, I think this really is an opportunity for people to learn, especially when we have so much development happening and legally for the most part, for people to find where that balance is and what they're comfortable with and how we can move forward to make sure that people aren't left out of the process or not understanding the process. So thank you, all of you, so much. I mean, I know we could probably talk about this for hours, and we got to most of our viewer questions, but people I think are definitely curious about what this is all about. So the hearing's coming up on Tuesday. For 8:60, and that has to do with the mediation process. So get out there and get your voice heard, because there are a lot of people out there who want to help make sure that we understand this process a little better. So mahalo to our guests and all of you. Next week at this time, PBS Hawaii will bring you the world premiere of the critically acclaimed Most Likely to Succeed. Now, this inspiring film brings school communities together in reimagining what our students and teachers are capable of doing. The reviews say after seeing this film, you will never look at school the same way again. So make sure you don't miss it. Most Likely to Succeed next Thursday at 8 p.m. right here on PBS Hawaii. And we'll see you February 23rd for the next edition of Insights on PBS Hawaii. I'm Laura Yamada. Ahui ho.